Okay, next item is 9B. Consider presentation by Deputy District Attorney Rickley Kelly with the Ventura County District Attorney Office on gun violence restraining orders.
Thank you, Mayor, council members, staff, and members of the community. My name is Rickley Kelly. I am a prosecutor.
I'm sorry, I butchered your name.
That's not the first time, and I'm sure not the last. No offense taken. I'm a prosecutor at the Ventura County District Attorney's Office, and I'm here on behalf of Ventura County District Attorney Eric Nazarenko and the Ventura County Family Justice Center. So I first want to thank you, Councilmember Castro and Chief Hendren, and any other attendees at the Ventura County Family Justice Center strategic planning meeting we had last week. But I'm actually here to talk to you about a really pressing issue. There is an essential tool for preventing mass violence that very few people are actually aware of. And so we at the Ventura County District Attorney's Office are working to spread awareness of this tool, and that is vital for preventing gun violence in our community. So we all are likely familiar with restraining orders issued in either a domestic violence context or maybe civil harassment. But there's actually another form of restraining order that is very different because it does not protect the individual. It protects the community at large. It protects the community from gun violence. This restraining order is considered a gun violence restraining order. And I want to talk to you about why it came to be and how it can be used to prevent gun violence in our community. Not long ago, about 10 years ago, in our neighbor to the north in Santa Barbara, there was a tragedy resulting in the death of 6 individuals and injuring 13 people. This tragedy, unfortunately, was probably avoidable. However, there was a gap in the law. This loophole, this lack of legal mechanisms resulted in a mentally ill young man injuring and killing these people. The family had raised these issues. People close to the shooter had raised these issues, but there was no legal vehicle to remove the legally purchased firearms in this case. So the legislature responded, and they responded in 2016 by issuing what some people know as red flag laws. By enacting these laws, it allowed law enforcement, but exclusively law enforcement, to obtain these gun violence restraining orders. They could file this one-page document in a crisis situation or in a situation where they had information that led them to believe that an individual posed a risk of harm to themselves or others, and that would allow them to make that person a prohibited person. They're prohibited from possessing firearms. That also allowed for the ability to obtain a search warrant and other mechanisms to obtain those firearms and remove them from the person that is now prohibited. In 2020, the law expanded further to allow not only law enforcement to obtain these orders, but it enacted a new type of order referred to as an ex parte order. This ex parte GVRO, or gun violence restraining order, made this restraining order available to members of the public. So not only law enforcement can obtain a GVRO, but actually close family members, roommates, significant others, teachers, or school employees could now file for a GVRO if they had information that led them to believe that an individual who had access to firearms or believed to have access to firearms could actually obtain a gun violence restraining order. Now, it should be noted that this is actually a bipartisan supported bill because it actually protects Second Amendment rights by ensuring the safety of the community and ensuring that these guns are not used inappropriately to inflict violence. The process is fairly simple. It does sound daunting because it involves 6 forms, but those are all found on the California Court's website, and they are fairly straightforward and user-friendly. So it's important to know this because unfortunately they are underutilized. Even GVROs related to law enforcement were hardly ever used in Ventura County. In 2016, only one GVRO was sought by law enforcement. 2018, there was 4, and so on and so forth. In 2023, there were 46. So a vast improvement, but still work to be done. And this is not as if we are on a witch hunt to obtain people's firearms. The legal mechanism for obtaining a GVRO includes an affidavit as well as a review by a judge or commissioner. So there is a legal checks and balances to ensure that this is a legitimate process and that there is a legitimate risk. Now, it's great to hear that so far, as of tonight, I just checked the statistics, and through August of this year, we have already filed 42 GVROs. So we are on track to improve upon this number. But what should be noted, all of those GVROs that have been obtained by that exclusive to law enforcement. So law enforcement have been the only ones filing for these. And part of that, we believe, is because the community is not aware of this tool. And so public awareness is critical. Only 66% of the population in 2020 had never even heard of the term red flag law. They'd never heard of the term GVRO. And so they certainly wouldn't know that if a family member or a former significant other was exhibiting threatening language or erratic behavior, that they had access to guns, they wouldn't know that this tool is available to them. Law enforcement actually was very similar. As of 2021, 56% of officers had never received training on GVROs. But here at the district attorney's office, we're making an effort to change that. We're getting out into the community and speaking to individuals like yourselves. We have trained the vast majority of law enforcement in Ventura County, much in part contributing to those higher numbers. We are here in the Ventura County Sheriff's Department, much in part thanks to Chief Hendren. We have filed, the Sheriff's Department alone has already filed 12 GVROs this year. So we are making improvements, and so that's part of the reason we want to make sure that people are aware that this tool exists, because gun violence has no place in Moorpark, and it has no place in Ventura County, and we want to make sure that we are exhibiting everything we can, we're utilizing everything we can to put a stop to it. So the end of my presentation is really just a call to action to please take this information home with you to your organizations, spread the word, make sure that people know that this tool exists so that if you or someone you know poses a risk, that we can put a stop to it before we see more headlines, more statistics, more tragedies, and more lives lost. And with that, I will turn it over for any questions.
Great, thank you. I got a question. So when you mentioned that if there's a reason to believe that someone's a risk to someone for violence, gun violence especially, what constitutes what that risk is? And I'm not talking about just the blatantly obvious ones we talk about all day, which all these things you're talking about here are, on your presentation, were preventable things that if you were to use this could probably prevent a lot of shootings. But I'm wondering, what is like the minimum amount that someone needs to be threatened by? Is that perception of threat or a real threat?
It has to be considered a credible threat of safety to themselves or others. So the credible threat, it would be ultimately determined by the judge to determine if you meet that threshold or not. This is fairly new litigation. This is fairly new legislation, excuse me. And so there has not been a great deal of litigation really honing that in. However, the legislature did enumerate some very specific things, like the person has recently acquired body armor. That can go to heighten or be a reason to grant a gun violence restraining order. And so there's kind of a list of things, many of which you might expect, but certainly verbal threats of bodily harm to themselves or others would be about the kind of the standard that we probably see the most. This often comes from our mentally ill individuals. And so it kind of works hand in hand with some of our welfare and institution code laws that do allow for us to put someone on an involuntary hold, things like that. but sometimes we may not have someone who rises to the level of a mental health hold, but their threats and their access to firearms may make this an appropriate avenue to go the gun violence restraining order route.
Okay, so you said if you purchase body armor, that's a red flag. What if you're scared of gun violence against you and you purchase body armor?
You'll definitely want to consult with an attorney before making any purchases of body armor. But that is an enumerated reason to consider a GVRO.
Yeah, okay. So I think these all make a lot of sense. And I think like sometimes you hear the opposing views of people can weaponize this just to get rid of guns in general, but with a judge being present, they're obviously weeding between what is real and what is not. So
absolutely. And there is a very clear process. So basically the way it works is if an individual, like I said, unfortunately, we have not had any examples in Ventura County, but the legally outlined process is that if a community member filed for an ex parte GVRO, they would file for that GVRO and it would be in effect for a period of time until there was a formal hearing in which the respondent would have an opportunity to be present and sort of appeal the issuance of that original GVRO before a permanent one went into effect. And so essentially, if someone did attempt to weaponize this and somehow the judge did not catch it, which fortunately we have a wonderful bench here in Ventura County, and specifically we have a commissioner who oversees the majority of these, and she is very well educated on this area of law. So she would likely catch that this was not a legitimate basis. But even if she didn't, by that full hearing, you would have an opportunity to present evidence on your own behalf, to cross-examine, to question, to challenge the evidence that was presented by the petitioner. And so you'd have an opportunity to essentially obtain due process.
Okay, sorry, I got one more question. Is that cool? So if someone got into a big verbal altercation with someone, and that was, that was all it really was, but that person knew the other guy had a gun, but never threatened any violence on anyone, could that person have a credible way of getting a gun violence restraining order on that person just because he knows he has a gun, they had a fight? Is that something that could happen?
Potentially, and unfortunately I'm gonna have to give you the most lawyerly answer, and I look to City Attorney Ennis because I'm sure he would say the same. Well, it depends, because it really is going to be case specific as to what the threats, if there were threats obtained during the fight, if there were references to firearms in the fight, things like that are going to play a part in that determination. So unfortunately I can't give you a hard and fast answer, but yes, that certainly could be a consideration, and we do see that in the domestic violence context, in other situations as well.
Okay, thank you.
First of all, I want to thank you for your presentation and the work that your office does, and reiterate a point you made that gun violence has no place in Moorpark in Ventura County, and it's great to see that supported through your office and through law enforcement. I have a question about the victim's rights and the victim's privacy here. What happens if an allegation is made and it is not deemed to have, by the judge or the commissioner, to have enough evidence? Is that allegation publicly findable by he or she that is accused?
So the respondent, so if I were to file a GVRO against John Doe, John Doe would have to be served because he would have to have the opportunity to challenge the evidence against him. So he would learn that there was the petition, and of course he would learn there was the petition because his firearms would be seized. So just by nature of a GVRO, he would know about it. However, as far as publicly available, these are filed confidentially, and so our Ventura County Superior Court does not post these documents. Many of our court documents are available scanned online through the Ventura County Superior Court portal. These are not. So there are efforts made to protect the victim's rights, and certainly if it were in a particular context like domestic violence, human trafficking, et cetera, there are overlapping laws that would allow for their confidentiality. But if it were sort of your, we'll use the 2014 example, if it were a family member who was filing for a GVRO against the shooter in the Isla Vista case, then they would likely be making their information known to that individual, and that is sort of inherent in the nature of due process.
Thank you for that clarity. in domestic matters, as you no doubt are aware, sometimes people say things that are untrue. In that situation where that information gets presented and the guns, it sounds like, are immediately seized for protection purposes, which makes sense, what happens? Are they stored? Is the person charged for storage? Do they have the right to get their firearms back if they were deemed to not be a credible threat? And if they are deemed to be a credible threat, then what? What process is there for that person, if any, to retrieve them? I imagine that's all been thought out through.
Yes,
through the process.
absolutely. And so there actually is a unit within our office called the Firearm Relinquishment Unit, and they work with law enforcement to ensure that these individuals, if they become a prohibited person, whether it be via a GVRO, a temporary restraining order, a civil restraining order, or a criminal protective order. Those are all avenues in which someone might become a prohibited person, or they have a felony conviction. Then the court would set a firearm relinquishment hearing, typically, and the individual would have to show proof that they either sold, that they provided the firearms to law enforcement for storage, or destruction if they choose that avenue, or they can actually pay a licensed firearm dealer to store them if they so choose. However, they cannot be in possession of them, and they have to show receipt that they no longer own firearms. Now, in the particular situation of a GVRO, law enforcement would likely be seizing those if they're issuing a GVRO on site via the emergency protective order or emergency GVRO that I displayed on the screen. They would be seizing them right then and there, and they would be booked as evidence or property depending on the context of the situation. They would not be immediately destroyed or auctioned off or anything like that. Certainly nothing would happen to those firearms until the individual would have the opportunity to contest the GVRO at that hearing, at which point they would be able to, like I said, determine the credibility of the threats against them or challenge the credibility of the allegations made against them. And then at that point, either the GVRO would be granted, in which case they would no longer have access to the firearms and sort of the point is moot, or they would successfully defeat the GVRO and they would be able to reobtain their firearms. And I will look to Chief Hendren to see if that has been your experience or if you have anything to add on that.
No, that's exactly correct. We would take them, book them into evidence. They would be held there until the court proceedings were completed. And then if the individual was allowed to get them back, there's a process in place that would allow them to do that. And if they weren't, then the court would be able to determine what happens to them, whether they're sold or destroyed.
Okay. Thank you for the education and the clarity. I appreciate it.
You bet. Thank you.
Dr. Castro?
I just had a quick question. You mentioned like two really big concepts, domestic violence and hospitalization. The hospitalization scenarios that you mentioned, oftentimes they're really temporary. They could be 24 hours, the holds could sometimes be a week, but at some point, the whole mechanism is designed to have that person out because those are designed to be temporary. Domestic violence is a fluid situation. Either way, there's a victim in different phases of that. So just can you talk about how the Family Justice Center is an asset as people are navigating this system? Because they are victims. They're even if they are trying to do quote unquote the right thing in doing it the legal way, it isn't necessarily a linear process. So can you talk about some of the assets of the Family Justice Center and how that could assist them in this process?
Absolutely. And for those of you who aren't familiar, the Family Justice Center is sort of a one-stop shop for victims. We have on site a DVRO clinic. We have DA, District Attorney Victim Advocates with our Victims Crime Unit. We have legal aid. We have interface child and family services available to discuss human trafficking and domestic violence victim advocacy and services. We have CPS, CFS, APS, probation, the district attorney's office. I actually have an office at the Family Justice Center. So it's sort of a one-stop shop model for anyone in crisis dealing with victimization. And so it works to essentially prevent further victimization. We safety plan, we crisis counsel, and we have mechanisms to assist with the filing of a GVRO should that be something that is sought. So we do have a family justice center in the city of Ventura. We are currently building the Carmen Ramirez Family Justice Center in Oxnard, and we are seeking to build or find a building for the East County Family Justice Center in one of our East County cities. And so essentially that model serves to serve victims in a holistic, multifaceted effort to ensure that we can approach all aspects of it. We can help you get a domestic violence restraining order, but we can also help you get mental health services if that's something that's needed. And so it's all in one place, because we recognize that when someone is dealing with trauma and is in crisis, giving them a laundry list of errands to go and run to make sure that their needs are treated is not beneficial, and frankly it often results in people not receiving the help or the services they need.
Thank you.
Thank you.
I got a question. You said access to firearms. How do you define access to firearms?
It's actually defined in the penal code, but access to the firearms basically means if you have firearms registered to you, or it's believed that they are in your house and within your ability to retain possession of them. So for example, we do deal with situations where it might be a child who is exhibiting threatening behavior. Maybe they are in mental health crisis. Maybe they are dealing with situation that is leading to them exhibiting threatening behavior. But the parents are the possessors of the firearms. If they are able to show that those firearms are secured safely and as they should be under the penal code, it's literally a crime for them to not have them secured, then we would not take action. That would not be possession or access to firearms, because they don't literally have access if we can ensure that they're secured. We would likely be working with law enforcement to make sure that happens. And there have been situations statewide where we've gone to the effort of actually having the parent sign an affidavit saying, hey, I have access, or I have firearms registered to me. I am not prohibited. I'm a legal possessor of those firearms, but they are secured. These are the efforts I am taking to ensure that access is not granted to my child who is suffering this issue. And that kind of is a level of insurance to make sure that like a GVRO is not needed for the parents, because at that point, them not safely securing or storing the firearms presents a whole nother issue, as we've seen in Georgia or in other jurisdictions. And so we're definitely conscious of that. But as I said, this is a bipartisan effort. This is not an effort to take away anyone's Second Amendment rights. And so we certainly are not coming for everyone's guns. We're certainly not trying to take a lawful possessor's guns simply because they have a relationship with someone who is dealing in crisis.
Yeah, thank you. And the reason I was asking is because we've seen multiple times that mentally unstable kids are the ones taking the guns from their law-abiding parents, and then obviously it's an issue. Does this also apply to other types of weapons too, or is it only firearms?
It is right now specific to firearms. I don't know if the intention of legislature would be to change that, but at this point it is specific to firearms.
Great, thank you. Any more questions? Well, I want to thank you for the presentation, and thanks for coming out. This is definitely an issue we're facing in our nation right now, and hopefully we can.
Thank you so much. And if anyone has any questions, I do have my information on the screen. Additionally, Freddie Padilla is one of our amazing investigators with our firearm recovery unit. And it's interesting, the question that you brought up regarding the children, he actually works very closely often with parents in these situations. And sometimes the best solution is that the parents find an alternative storage location simply for their own safety and for their own benefit. So Freddie's an incredible asset to the DA's office and to Ventura County, because he is an expert in firearms and he's excellent at dealing with this GVRO firearm recovery situation. So please, if you have any interest, please take down his information. And with that, I will turn it back over. Thank you.
Great. Thank you.